agency relationship. An agency relationship is one in which one person called an agent is authorized to do acts for another person called the principal, and therefore bind the principal to a third party that they're dealing with on behalf of the principal. So these relationships can arise either informally or through something like a formal written agreement, like an employment contract. Now, they also exist in all kinds of relationships, human interactions throughout business. An attorney is the agent for the client, who would be called the principal. Anybody who has a job working for someone else is going to be some sort of an agent for their employer, who is called the principal. So we have all kinds of examples of that. Business organizations run on agency. Agents run the business. Agencies organized, manage the business. Agents are acting on behalf of their employer. The heart of what makes an agency relationship is something we call authority. If you don't have authority, you don't have an agency relationship. And we have three kinds of authority. We have something called express or actual authority is what is commonly called, actual authority. And that's where the principal directs the agent to do a task. And that task may be directly instructed to do, or it could be implied that the principal wants that agent to do that task. More about that in a bit. Then we also have something called apparent authority. And here we're talking about the principal's conduct makes it appear to a third party that the agent has that authority. We're going to talk more about that in just a moment. And then the third kind of authority is ratification, which is a retroactive authority by the principal, where the principal, after the fact, accepts what an agent has done and accepts the contract, for example. Let's take them one at a time. The first one, actual authority. When the principal has asked the agent to do a task, the principal has granted actual authority to the agent. Now, if the particular act that we're talking about was specified, then that is what we would call express actual authority. If the act that we're talking about was not specified, but it's something that's necessary for carrying out the task that was specified, well, then we would call that particular task to be, and that particular authority it's implied authority, implied actual authority. But here it's the principal communicating to the agent. Principal communicating to the agent, you have this authority to act on my behalf in dealing with the third party. Now, this actual authority continues until either the principal or the agent terminate it. The principal saying you're fired, or the agent saying I quit, or the two of them agreeing mutually, all right, let's just part ways, or that maybe they have a written agreement that governs their relationship, and that written agreement calls for the agency relationship, the employment, for example, to end at a particular point. Or if either the principal or the agent dies, well, then that will terminate it as well. Apparent authority. Here, we're not talking about the principal communicating to the agent. What we're talking about here is the principal communicating to the third party through the principal's actions, leaving the third party with the impression that the agent does have authority. principal's conduct may cause that third party to reasonably believe that there is that authority being granted from principal to agent. And if that does happen, then the principal is going to be bound. An example would be a principal hiring someone to be a purchasing agent, giving them the title purchasing agent. But the actual authority that they give them, the actual express authority, says you can only purchase sporting goods, for example. But the purchasing agent goes beyond that and purchases other things. And the vendors that are dealing with that, the third-party vendors dealing with that purchasing agent, all they know is he's a purchasing agent for this particular company. They don't know the limits on his actual authority. So basically, through the actions of the principal, allowing the agent to have that broad title of purchasing agent and whatever other things that they presented to third party, left the third party with a reasonable belief that the agent did have that authority. So we call that apparent authority. And then that third type of authority, ratification, that I mentioned just a moment ago, the principal can accept an obligation created by the agent when the agent really didn't have any kind of authority whatsoever. It's retroactive. Let's say, let's talk about a paralegal. Paralegal working in a law office needs some office supplies. The lawyer, they're not the office manager, the paralegal's not the office manager, it's a paralegal, but needs some supplies. Lawyer says, or the lawyer says, go down to the office supply place, get what you need. Well, while they're down there, the paralegal thinks, well, I need a printer too, and so they buy a printer and bring it back. Lawyer says, you weren't authorized to buy the printer, but go ahead and keep it anyway. I guess we needed it, we're going to keep it. Well, the lawyer has now ratified that particular purchase and is now going to be bound to pay the bill for it. Now, we're talking about a agency relationship, two parties in this relationship, the principal and the agent. They're going to have duties flowing back and forth between them. Agency creates a fiduciary relationship where the agent is a fiduciary for the principal. Fiduciary, it's a position of trust, a relationship of trust, high trust, of one person in another, with a duty of loyalty owed by one person to the other. And in this case, it's the agent that must act in good faith for the principal. Here are our duties that are owed by the agent to the principal. In this column, I have duties that are owed by the principal to the agent. So let's take this column first over here. Duties of the agent to the principal, the duty of performance of the task, duty of obedience in performing the task or obedience during the relationship, duty of care to act as a reasonable person would act for the principal's business on behalf of the principal. We use a reasonable person standard. The agent has to act as a reasonable person would act regarding their own business. Duty of loyalty. The agent owes loyalty to the principal. No conflicts of interest. Nothing, no business business ventures that the agent would undertake that would conflict with the goals and the best interests of the principal. They can't enrich themselves at the expense of the principal. They owe total loyalty to the principal. Looking over here, what does the principal owe back to the agent? Well, duty to compensate, duty to indemnify and reimburse. If the agent spends some money, has some costs in doing their job, the principal has the duty to reimburse those costs or to indemnify or protect the agent from any costs or expenses or exposure that would happen in the course of doing the principal's business. Duty to facilitate the agent's performance. Principal is hiring or authorizing the agent to do acts for the principal. Well, along with that is a duty the principal has to the agent to facilitate that by giving the agent the tools that the agent needs, giving them the means to complete the task and to the objectives of the agency. And of course, these duties can be affected and expanded primarily, but can be affected by agreement of the parties. Frequently, you would see that in an employment contract of some sort. But an agreement between agent and principal can affect what their duties are actually to each other. And then finally, we have liability. What's the liability to the principal because of this relationship that they have? Most of what we've talked about so far have dealt with business dealings that the agent will bind the principal to in dealing with third parties. Here, what we're talking about is tortious conduct on behalf of the agent, where the agent may commit a tort. And well, what impact does that have on the principal? Well, the principal can be held for the acts, the tortious acts of the agent. Now, and that's because the agent has, the principal has the power to control the agent. Therefore, the principal is responsible. Now, this is what we call vicarious liability, being responsible for what someone else does, vicarious liability. And the doctrine that is called is the doctrine of respondeat superior, which in Latin means let the master answer. Let the master answer for the acts of the servant. And now the servant in this case, or the agent, is still liable for their own torts. Even if the principal is liable, the agent is always going to be liable for their own torts. The question here is, can a third party who's been harmed by the agent get the principal to take responsibility, to be liable under the law? Now, the general rule is that principal will be vicariously liable, will be liable under the law for the torts of the agent if the agent is a servant. A servant, that's a type of agent that the principal has a right to control the details of the work. We'll get to that in just a second. So if the agent is a servant and the agent is acting in the course and scope of the agent's employment, then the principal is going to be liable. Now, we have this distinction between servant and independent contractor. The main factor that makes that distinction is, does the principal have the right to control the details of the work of the principal, of the agent? Does the principal have the power, the right to control what the agent is doing? And if the answer is yes, then the agent's going to be a servant. If on the other hand the principal is saying, I don't care, agent, I don't care how you do it, just take care of, I'm hiring you to get a particular job done. How you do it, when you do it, where you do it, what tools you use, that's all up to you. Well, that's going to be an independent contractor. And the principal there won't have the right. They've given up the right to control the details of the work. Okay. Now, then we have this notion of frolic and detour rule. If the agent is not in the course and scope of employment, but on a personal frolic while doing the job, or in the course of doing their job, they take a break and they're on what's called a frolic, like going from point A to B on the job, and then they take a detour to X, and they do some sort of tortious act there. And before getting back on track at points C and D, well, they're outside the course and scope of employment, and the principal is not going to be liable. So once again, the general rule, if they're an agent, if the agent is a servant, subject to the details of their work being controlled by the principal, and if they're acting in the course and scope of employment, then the principal is going to be liable. And that's an overview of the law of agency.